So let's dive right into this explainer by really grounding ourselves in the incredible high stakes of post-apartheid South Africa. Just take a moment to digest that quote. We're looking at a brand new nation in the mid-1990s, desperately trying to fix a deep, painful, and incredibly complex history of disrupted education. I mean, think about the sheer scale of that task for a second. Trying to unify a fractured, highly unequal system into something that actually serves everyone fairly. But as the new government very quickly discovered, rebuilding a massive national system from the ground up brings up a really tricky structural question. Who actually gets to be in charge? Welcome to today's explainer. We are going to unpack a seriously dense, dramatic, and historic 29-page constitutional court judgment from 1996. This single legal document fundamentally shaped how power is shared in South Africa. It's an absolutely fascinating story of grand national ambitions colliding head-on with a fierce desire for local autonomy. Here is our roadmap for today. First up, the education policy clash. Second, the power struggle. Third, we'll look at the American comparison. And finally, the final verdict. All right, part one, the education policy clash, specifically focusing on the National Education Policy Bill of 1995. We begin our story right in the thick of the mid-90s with a drafting of this specific bill. This was envisioned as the absolutely crucial piece of legislation meant to rebuild a country's schools, set standard curriculums, and essentially unify a heavily fragmented system into one cohesive whole. Now, the bill outlined some very clear and, frankly, much-needed objectives. It tasked the National Minister of Education with the usual bureaucratic heavy lifting, right? Determining overarching national policy, setting up mandatory consultations before those policies were locked in, publishing and implementing them, and, importantly, monitoring and evaluating education standards across the entire country. On paper, to the average person, this sounds like a perfectly reasonable, standardized plan to ensure quality education for all students. But its mechanisms for actually rolling out these goals instantly triggered a massive, high-stakes political dispute. Three major political parties pushed back, and they pushed back hard. The National Party, the Democratic Party, and the Inkatha Freedom Party formally united to petition the brand new Constitutional Court. Their core fear? Well, they believed the National Minister of Education was trying to act like an absolute dictator, using this bill to force his will onto the local provincial governments. You have to remember, in a newly formed democracy that had just emerged from an authoritarian past, the fear of centralizing too much power in one person's hands was a very real, very raw nerve. Which brings us to part two, the power struggle. National authority versus provincial autonomy. To truly understand why these parties were so genuinely afraid, we need to look at the legal battlefield itself and how the young South African Constitution actually divided power between the center and the regions. Under the new Constitution, education is legally defined as a Schedule 6 functional area. What that actually means in plain English is that it's a shared responsibility. The provinces have the competence to make laws about their own local education, but so does the national parliament for the whole country. It's honestly like having two co-captains trying to steer the exact same ship at the exact same time. As long as they agree on the destination, it's totally fine. But what happens when they want to turn the wheel in opposite directions? So the friction here is totally structural. On one side, you have the broad, absolute plenary power of the national parliament to make overarching laws for the entire republic. Plenary power essentially means complete general authority over a governing area. But on the flip side, you have the specific localized legislative competence of the provinces to make their own laws for Schedule 6 matters, like education. The burning question before the court was simply this: what happens when these two massive constitutional forces collide? Well, the challengers argued that specific clauses in the National Education Policy Bill crossed a massive legal line. They argued the bill would unlawfully force provincial executives to blindly implement the national government's policies, even if those policies directly conflicted with their own local plans. Just imagine being a local leader and suddenly being forced to scrap all your localized plans just because a distant national office said so. They feared it would literally force provinces to amend their own laws, effectively empowering the national minister to impose his will and completely strip away their hard-won provincial autonomy. Moving on to part three, the American comparison, or what I like to call the precedent twist. Because what makes this case so incredibly fascinating is the highly creative legal strategy the challengers used to make their point. In a really surprising twist, they tried to use American legal precedent to win a South African constitutional argument. Get this, they relied heavily on a 1992 U.S. Supreme Court case called New York v. United States. And yeah, surprisingly enough, that case was actually about the disposal of radioactive waste. But the core legal principle at stake was highly relevant to them. In that U.S. case, the court ruled that the federal Congress cannot simply compel states to enact or administer a federal regulatory program. The South African challengers argued that exactly the same logic applied to education here. Just as the U.S. Congress cannot compel American states to deal with toxic waste, South Africa's national government absolutely cannot compel its provinces to manage schools a certain way. The Constitutional Court's response to this American comparison is basically a masterclass in constitutional architecture. Judge Arthur Chaskalson meticulously maps out exactly why South Africa is not the United States. In the U.S., sovereign states originally existed on their own, came together, and surrendered a portion of their power to a federal government while retaining all other rights. But in South Africa, the provinces were created from scratch by the Constitution itself. They didn't exist as sovereign entities first. They were newly drawn lines on a map, endowed only with the specific powers given to them by that specific document. Judge Chaskalson elegantly neutralized the challenger's entire argument with this one observation. He points out that South African provinces never had sovereign power to surrender in the first place. Therefore, trying to map American state rights onto South African provincial rights is literally like comparing apples to oranges. The American precedent was rendered completely ineffective. And that leads us to part 4, the final verdict. Was this coercion or cooperation? With the American argument meticulously dismantled, we finally arrive at the climax of the judgment. The court's deep dive analysis into what the education bill actually legally enforces. The court decided to look past all the political panic and just broke down the bill's actual mechanics into 4 sequential steps. Step 1, the minister formulates a national policy. Step 2, the minister informs the provincial heads. Step 3, they all sit down and consult within a dedicated council. And Step 4, if education standards are severely lacking, a province might be asked to prepare a remedial plan. By mapping it out this way, the court definitively proved that the legislation was designed as a framework for cooperation and dialogue, not as some coercive weapon. So here is the absolutely crucial point in how the court interpreted the specific language of the bill. The challengers were terrified of the word require, as in the minister can require a province to submit a plan. But the court clarified a massive legal distinction. Require does not mean compel to implement. While the bill can ask a province to formulate a remedial plan to fix failing education standards, it does absolutely nothing to legally force them to actually implement that plan against their will. In fact, when the 10 judges of the Constitutional Court scoured the entirety of the 1995 National Education Policy Bill, guess how many legal obligations they actually found that would force provinces to comply with national policy? 0. Literally none. Without further separate legislation being passed, the minister simply did not have the dictatorial power the challengers were so afraid of. Judge Chaskalson wrapped it up with a really profound statement on the nature of the young democracy. He wrote that in a system of concurrent powers, where 2 captains are steering the ship, establishing bodies for mutual discussion isn't a threat to autonomy. It's not just constitutional, it is absolutely essential. I mean, you just cannot run a country without talking to each other. The final verdict, a unanimous 10-0 decision by all the Constitutional Court judges. The bill was declared perfectly legal and not unconstitutional. The court impartially protected both sides. It protected the national government's right to plan and set standards for the country, while simultaneously protecting the province's right to govern themselves without being legally compelled to blindly follow orders. This landmark explainer leaves us with a profound thought to ponder. You see, the 1996 ruling wasn't just about a single education bill. It was a defining moment that mapped out how a newly unified country would hold itself together. It asks us to consider, in the delicate balance of any growing democracy, is progress best achieved by pulling together under one unified national vision, or by trusting the autonomy of local communities? Think about how that exact balance plays out in your own local governments today. Thanks so much for joining me on this explainer, and I hope to see you in the next one as we keep exploring.